By democracy's definition, freedom of the press is vital to the survival of its existence. Without the check and balance that this First Amendment right provides, the nation that prides itself on being governed by the people would not truly be one of freedom. Throughout our country's vast history, we have witnessed many points in which this necessary right has been stripped away and reaffirmed. One of the most significant Supreme Court cases that proved freedom of the press is not something Americans will budge on was the case of Neer versus Minnesota in 1931. Neer versus Minnesota created a precedent for no prior restraint by the government and in turn upheld freedom of the press when it was in a vulnerable place. It also ruled that this right is not just applicable to the federal government, but to states as well. This court case reaffirmed freedom of the press and created an accountability for the government through media by making politics truly the people's business, by keeping this freedom safe as new technologies emerged, and by adjusting the culture in a way that gave people the ability to use their voice. By 1931, freedom of the press had been compromised and reinstated by the passages and overturns of the Espionage Act of 1918, the Sedition Acts, and many more. This meant that while in 1924, John Morrison published an article in a magazine called Ripsaw that slandered government officials and made horrible accusations involving corruption and scandals. Minnesota legislator put into motion the Public Nuisance Bill in 1925 as a reaction to this. This gag law stated that if a judge with no need for a jury saw that if a publication was, quote, a nuisance, end quote, it would be shut down. Before John Morrison was able to fight the closure of his newspaper, he died, leaving the bill standing strongly without opposition. In 1927, Howard Guilford and J. Neer began the publication of the Saturday Press. This newspaper was not necessarily a credible news source and was in fact guilty of being incredibly anti-Semitic and full of conspiracy theories. Nonetheless, it was still a free publication and should not have been subject to prior restraint, which is exactly what Neer argued. In the same year, the article that made County Attorney Floyd Olson file a complaint to the state about the Saturday Press stated, quote, there have been too many men in this city, and especially those in official life, who have been taking orders and suggestions from Jew gangster, Neer charged. Therefore, we have Jew gangsters practically running Minneapolis, end quote. This was one of the more tame and least offensive quotes from the article. A temporary restraining order was then placed against the Saturday Press, which was upheld due to the public nuisance law, also known as the Minnesota Gag Law. This outraged Neer, prompting him to fight back against the order. In April of 1928, the Minnesota Supreme Court tried the case and did not find in favor of the Saturday Press. In May, the Minnesota Gag Law remained in place. That same year, the restraining order against them is made permanent by Judge Matthias Baldwin. Though this was originally a small case, the outrage amongst journalists that it caused brought it into national view. On April 24, 1930, the American Newspaper Publishers Association stands in support of Neer and agrees to cover all the legal fees for the case. The next year, the case is officially brought to the Supreme Court after appealing the ruling of the Minnesota Supreme Court. With the smallest margin of victory possible, 5-4, the U.S. Supreme Court rules that the Minnesota Public Nuisance Law of 1925 is unconstitutional. The ban is removed on Neer's publication, and freedom of the press is once again restored in America. One of the biggest backers of the case, the Chicago Tribune owner, Robert McCormick, reacts by printing the news in a full-page headline. He says, quote, the decision of Chief Justice Hughes will go down in history as one of the greatest triumphs of free thought. The Minnesota Gag Law was passed by a crooked legislator to protect criminals in office and supported by a state court as feeble in public spirit as it was weak in public acumen, end quote. Chief Justice Hughes would also comment, quote, this statute raises questions of grave importance transcending the local interests involved in a particular action. It is no longer open to doubt that the liberty of the press and of speech is within the liberties safeguarded by the Due Process Clause of the 14th Amendment from invasion of state action, end quote. This decision had impacts felt across the nation and even into present-day politics. The accountability that it created makes a huge difference in the political climate because the politicians now know that they are under close watch from the media and that they cannot silence opposition aimed at them. This is important because it not only affirms the check and balance that the press provides, but also allows Americans to be fully aware of and involved with the dealings of their government. Without this case, we would not have the open relationship with the government that is so necessary today. Not only were politics themselves changed, but American culture was adjusted as well. When the people are no longer held under prior restraint, they have a change in attitude, which adjusts the culture. The power and upper hand is no longer with the authority. The people can critique them and disagree freely under the protection of this Supreme Court ruling. Before, the media climate was one of control and censorship, but that has switched. This needed culture switch is what makes this case so important. The level of trust people have towards the government is constantly varying. This case and the culture that it created makes all levels of distrust and trust fair game for the people to publish and speak on without fear. The political and cultural changes brought on by this case are especially relevant today with the current climate around technology and its connection to freedom of the press. The internet now plays a large role in how people ingest the news from the world around them. There are constant posts, live streams, and even tweets providing Americans with play-by-play real-time coverage of the behaviors of our government. If Neer versus Minnesota was never passed, the way we get our information today might look completely different. Technology evolved and expanded at such a fast speed, and it was necessary for the media to keep up with it. As the press has expanded, the current government has been unhappy with the way things are being reported, but because of this court case, that unhappiness holds no ground or leverage. We have seen many historical impacts from this court case. There's a direct connection of this case to that of the New York Times publication of the Pentagon Papers in 1971. If Neer versus Minnesota never won, the truth about the Vietnam War and the practices and secrecy from our government surrounding it would never have been able to come out to the general public, and we wouldn't have learned the truth about what the country we take so much pride in did in Vietnam. We are even seeing direct impacts in 2018. The current administration of the United States is calling credible news sources fake news and is threatening lawsuits against journalists. If Neer versus Minnesota never happened, he might have the power to shut down any news source that questions him. The press is once again under scrutiny, which is why it is so important that Neer versus Minnesota set the precedent that government has to leave that freedom alone. Right now, there is an increasing number of journalists being stopped at the U.S. border, and there have been arrests for writers just covering the protests at Little Rock and the most recent inauguration. Right now, the U.S. is ranked 43 out of 180 countries on the World Press Freedom Index. This means that we are doing a worse job at protecting the media than 42 other countries. And if it weren't for Neer versus Minnesota, we might be a lot lower on that list. Neer versus Minnesota will forever be one of the most important Supreme cases in regards to freedom of the press. Without it, we would not have true freedom of speech or freedom of expression. Though the article J. Neer wrote was not journalism at its finest, the effect of the court case was. Thanks to this ruling, America can remain a free democracy with the people at its center.